Viewers, welcome to the Personal Injury Law Show. This is a show that talks about everything current in the law of personal injuries and obviously of importance to you, the viewer. My name's Tony Carbone. I'm a personal injury lawyer with 30 years experience. With me tonight I've got a partner in the law firm in transport accidents, Don Maffia. Good evening, Don.
Good evening, Tony. Good evening, viewers.
And a lawyer in a law firm in transport accidents, Alistair Boughton. Good evening, Alistair.
Evening, Tony. Evening, viewers.
Now, Tony, I understand you want to dedicate tonight's show to someone.
Yes, look, tonight, viewers, I want to dedicate the show to the Halkich family. Today's the birthday of Alan Halkich, who would have been 24 years of age. This young fellow committed suicide in February 2009. He was subjected to cyberbullying, Don and Alistair, and sadly he took his own life. The family, his father saw fit to set up the foundation, the Bully Zero Foundation, because of his death, and in his honour they've started the foundation, of which I'm a member, and his father's also on the board, so you know, this is in his honour and the family. So let's hope that anyone out there that's got problems or suffering or been subjected to cyberbullying and things like that do speak to the foundation and also seek help.
Yeah, and Tony, I think cyberbullying, I mean, these days includes, obviously, it could be Facebook, text messages,
Twitter,
email, Twitter, and it's an endless list, isn't it? And it's a tragic story.
It doesn't. Alice, it's a very sad case. I mean, he would have been 24 today, so he was a brilliant young man, you know, captain of his footy team, things like that. So it just shows you, it doesn't matter how strong you are, sometimes you think there's no way out. So it's important that people do seek help and also get in touch with the foundation. They've got some really, really good life supports these days.
Now, Tony, let's talk about what's in the news.
Yeah, look, there's been a lot of stories. This story of the tradie who sues after a water slip. Alistair, what's this about?
It's about a tradie who's come across a waterfall in Parks, Victoria. And he seems to have gone for a bit of a swim in the waterfall, slipped and injured himself.
Don, is it a hard case or has he got legs, pardon the pun?
I think there was signage about it, and one of his basis for his claims is to say people who the council do not have regard to people who may be distracted not seeing the signage. So I'm not sure what that means.
Well, there's been a lot of cases, especially in supermarkets, where there's been signage, watch out for wet floors, and people are still wondering.
Yeah.
There's a couple in New South Wales.
Yeah.
So,
and I think you got to look at, obviously, the type of signage. I don't think having a signage will abrogate your duty to look after someone's safety. So I think you've got to look at the whole fact scenario. So, look, Tony, I think considering all that, look, it's a claim where there's a hidden risk.
Yep.
You've gone into water, slippery rocks, should have been well aware of it. What more they can do? I mean, always hindsight's a benefit.
Yep.
So, look, it's a claim. And
it's a tough case.
And Don, part of what he says is that the waterfall is so enticing, it encourages people to go in and
that's probably why
take a bit of a risk.
Yeah. Well, you know, Tyson diving in head first before knowing what's the risks involved. I mean, look, there is a bit of balancing act there as well. But yeah, look, I'd like to see more facts about the case as well. We've only got a brief summary, but it's an interesting one, and these cases aren't easy. Yep.
Anyway, we'll see what happens. Lead paint brain damage claim. Don, this is an incredible story of a case of failing to supervise.
Well, yes. Well, this is where there's a student at a school, primary school, where it's supervised, and it should be a supervised school, so looking after kids with disabilities and needs. Where at recess, they were doing some renovations at the school, and at recess, this child or this student has gone ahead and ate some lead paint. So obviously no supervision, and now he has suffered lead poisoning, Tony.
We all know the dangers of lead. It's in our petrol, and they're trying to reduce that.
Yes.
That's why we've got unleaded petrol these days. But it sounds like he's got some pretty debilitating sort of injuries there.
It does. And look, it includes symptoms such as sleep difficulties, vision disturbance, violent outbursts, which is very concerning. I think considering that there is these type of dangers around, lead paint is still around in old schools, and they strip it down, and the students have gone ahead and ate it.
Well, he's autistic, Alistair, so he's already starting out
that
with
might make him a little bit more vulnerable
so
to then suffering a further injury from the lead poisoning.
But he should have been, if he's autistic, supervision should have been pretty high.
I would have thought so.
Yep.
Absolutely.
Anyway. A woman gets $2.3 million for wrongful jailing. She got ordered to serve 12 years, for a murder. She did 10 years, then she's exonerated. Her conviction's quashed on appeal. This is a bit bizarre, isn't it?
And she's received $230,000 per year of incarceration. So it's interesting that that's the figure that they've essentially put on someone's liberty.
I don't think you can put a figure on someone's liberty, Don. 10 years behind bars.
Look, and this case got a lot of media attention as well, where she's been charged with soliciting to murder her husband, so conspiring to murder her husband, and it's come out that her convictions were quashed, and she spent 10 years of 12-year sentence incarcerated, and she's made a civil claim.
What happened to her
against the
husband?
state.
Was he actually murdered? Was he?
Yeah, he was murdered.
Oh, okay.
Yeah.
Okay.
So there is a whole story, there's a whole chain of events have happened. There's been media attention, and I'm sure there'll be a lot more coming out about it as well. But $2.3 million for 10 years in jail.
Sounds like a long time to have someone behind bars before they quash an appeal.
Yeah, that's the interesting thing. A whole decade's gone by before the appeal's been overturned or quashed. Perhaps some new evidence has come through that has resulted in this change in the decision.
I'll tell you what, wheels of justice move pretty slowly, don't they?
They do.
Yeah. Anyway, let's keep moving. This has got to be one of the most inspiring people going around, Don.
Yes.
This surgeon, Michael Wong, who was nearly stabbed to death not even 18 months ago, has invented this 3D printed technology to deal with surgeries on spines, and considering the amount of stab wounds he suffered, loss of blood and everything else, and he's back at work. It's new wave technology, Don. It's extraordinary, really.
Yeah, and look, traditionally when you're talking about back surgery with cases which involve like disc prolapse and affecting the nerves, usually what they do is take the disc out and fuse it together, so the recovery is very poor, what I've seen. So this technology is like an implant, and the recovery and healing is much safer and quicker for the patient.
And doesn't put as much stress on the other vertebrae.
Correct. Yeah, well, it's mimicking the actual spine. So rather than just fusing the spine, it's actually mimicking the disc space there. So, that's great. That we can.
I think it's a good time to get the doctor back on the show. What do you think?
I think to explain that,
Yeah, I think we should get him back. This country carnage on the roads, it seems to be a problem. Doesn't matter what year, doesn't matter what's said, doesn't matter what's done. Every time there's an accident on one of those country roads, there seems to be a fatality. There's been 8 people killed in 11 car crashes on the road of recent times.
And the new TAC advertisements in terms of bringing the road toll down to zero is very emotive and talks about the carnage on the roads in the country and in the city, and obviously it's unacceptable to have any fatalities.
Don, what do you think of that new ad? I think it's really, really hits a nerve, doesn't it?
Yeah, well, congratulations to TAC again. Yeah. They've come out with this cutting-edge sort of campaigns, and this is a new one, Towards Zero. And it's hits the spot, particularly with family people, understanding the way that it can affect these type of deaths on the road, affect so many people.
Viewers, let's take a quick look at the commercial Towards Zero deaths.
Last year, the road toll was 249. We asked Melbourne Victory fans what a more acceptable road toll would be.
80.
200.
Like 50.
I would say about 90.
Then we showed them what their more acceptable road toll looked like. And asked the question again.
0.
But what's interesting, Tony, is that Vic Roads are saying that reducing speed limits is probably an approach, but it's probably not the proper approach.
I think it's education. I don't know about.
Well, they're talking about barriers. No, so I'm not sure, but look. I
think just educate people not to be complacent and just to realise that when you're on these open roads, that things do happen.
Absolutely.
You know, it only takes a split second, doesn't it?
Yeah.
Anyway, we're going to go to a sponsors break. Viewers, stay tuned after the break. We're going to give you a TAC update. Welcome back to the show. Tonight we're going to give you a transport accident update. Before that, I just want to wish Janet Doherty, outgoing CEO of TAC, all the best in her future endeavours, and career. And welcome aboard Joe Calafiore, the new CEO of Transport Accident Commission. I'm sure he's going to be a really good addition to the commission, Don.
Yep.
Viewers, we've got a number of cases we want to take you through. The first one's a matter of King and Philcox. It's a High Court decision coming out of the South Australian jurisdiction. Alistair, tell us a bit about the facts of this case.
Well, this case basically involves a case about mental harm. The defendant, George King, was negligent in causing an accident which resulted in the fatality of the plaintiff's brother. Now, the question was whether or not the plaintiff was at the scene at the time of the accident. What had happened was the plaintiff had driven past the scene of the accident on about 5 separate occasions, not realising that his brother was in the accident. Approximately 2 hours later, he's told by family that his brother has died in a car accident, and at that point in time he realises that the accident which he's driven past on 5 occasions was the accident in which his brother's died.
Don, do we know why he went past the location 5 times? Is there any indication why?
I think he was running errands and also he was visiting his girlfriend. It was like close to where he lived.
Did he
So was going
suspect
to
that it
and
was
from.
his family member?
No, not at all. He didn't
Really?
suspect at all. So drove 5 times past, didn't realise, goes home, and I think his girlfriend's house, and 2 hours later his parents notified him that his brother passed away in the accident. And then he realised it was that accident. And he actually went to the scene once it was cleared up. He went to the scene and spent hours at the scene because realising that it was his brother he just drove past. And the point about this case, Tony, is that South Australia has legislated as to when a person can recover for what we call pure mental harm.
I want to highlight that. There's, under the Civil Liability Act 1936, and updated, obviously, many times, Section 53(1) limits the circumstance in which a plaintiff may recover damages for mental harm caused by an accident. If the plaintiff's not a parent, spouse or a child of a person killed, injured or endangered in the accident, he or she must have been physically injured in the accident or present at the scene of the accident when the accident occurred. Now, he's got there just after this accident.
Correct. So he got there in the aftermath of an accident.
Yeah.
Right, so not at the accident, but the aftermath.
So the issue is proximity, obviously.
That's right, and the High Court in this case refers to a previous decision of the High Court where it discusses the difference between
Well, before we get to the High Court,
accident
what
and
happened in the
aftermath.
first instance? What happened in the first instance?
Well, he was unsuccessful at first instance. The court held that there was a duty owed to the brother, but he wasn't present at the time of the accident. The plaintiff appealed and was successful
In the
upon
full court
appeal.
of the Supreme Court of South Australia.
That's right, and then the defendant appealed to the High Court.
Well, the first question was, Tony, whether or not there's a duty of care to prevent mental harm in these circumstances to a person, in which I say a person of normal fortitude in the plaintiff's position might, in the circumstances, suffer a recognised psychiatric illness. So that was how, I think, through the courts, particularly the full court and the High Court, and we'll get to results soon about the High Court, but it had that there was a duty owed.
Yeah.
But then we come to this Section 53 of the Civil Liability Act of South Australia, where it says, because he was not a parent, he wasn't a spouse or a child of the person killed or deceased, he has to be present at the scene of the accident when the accident occurred.
3 judges of the full court of South Australia said that he was present at the scene of the accident when the accident occurred. They accepted that he was there.
That's right.
Based on the evidence as we know it.
Yeah.
But the High Court...
Well, the High Court said they got it wrong, essentially.
I reckon they're splitting hairs personally, but...
I think they've taken a very narrow approach to the terms or to the words when the accident occurred.
Yeah.
And are pretty much limited to exposed to sights or sounds of the accident.
Well, Don, he was there, but he didn't know it was his brother.
Well,
The evidence was that he was there, just after the aftermath.
Well, during the aftermath, essentially, he saw the vehicles, he saw the car that had the jaws of life applied to it to extract
The occupant. Yep.
So he most definitely saw the aftermath.
Well, Don, what if his evidence was, when I went there, I had this feeling that it could have been a family member? Would that have set aside the test?
No, I don't think it would have. Because again, it's a very narrow approach that the High Court has taken, and they're saying, essentially, you have to see it happen. You have to be there when the actual accident occurred.
But he
not
was there.
the aftermath. Well, that's the dispute.
if he's not there when the accident actually happens, but he's there just after the accident, why isn't that?
Well,
it's part and parcel of
the High Court said that the aftermath is not the accident itself.
Yeah.
So there's a distinction at common law between the accident itself and the aftermath. And the High Court said, well, the legislation refers only to the accident, therefore it excludes the aftermath.
I think it's a very,
And we should say,
narrow.
Tony, that this is limited to South Australia because South Australian law.
Well, if it happened in Victoria, what would be the situation there, Don?
Well, if it happened in Victoria,
this is the reason why you need lawyers.
Yeah, exactly. You need to get the advice. Look, I think all states in Australia have now legislated, as far as I'm aware, to diminish the circumstances where people who suffer pure mental harm, not physical injuries, are limited or can recover
Well, you can
damages.
still recover in Victoria. I mean, but it's a lot stricter, obviously.
Yeah, and we spoke about it plenty of times on this show, but there is
In
strict
brief.
in Victoria. In brief, pretty much to get entitled to sue, you have to have what's called a serious injury, and a serious injury in psychiatric circumstances are limited to people who have 3 years of continuous treatment.
And it's got an impact on your domestic,
Correct.
working life,
Correct.
and what was the third one, Alistair?
Recreational.
Recreation. So it's a pretty tough test.
It's a very tough test.
And you'd probably need ongoing treatment over that period of 3 years, wouldn't you?
You need ongoing treatment from qualified medical practitioners.
And this just goes, if we compare each state is moving to try and restrict where people who suffer psychiatric injuries can recover damages. And Adelaide, my view, has probably gone one step too far.
All right, let's keep moving. James versus Maxwell. It's a full-court decision in the Victorian court. Do you want to give us the facts again, Alistair?
Essentially, this case involves two drivers heading along an outback country road. The road was an unsealed road, gravel road, and there's a head-on collision, essentially. And the question is, who's at fault for the accident?
Anyway, we're going to leave the viewers hanging on those words of yours, and when we get back, we'll take some more facts from Don, so stay tuned, viewers. Viewers, welcome back to the show. Before the break, Alistair was giving us succinctly the facts of this case.
That's right.
Where were you at, Alistair?
Well, essentially, as I said before the break, there was a head-on collision on this gravel unsealed road out in the country. The plaintiff was a motorcyclist and the defendant was driving a vehicle. The head-on collision occurred and the question was who's at fault, on what side of the road was each vehicle as they came to a bend in the road. And the bend in the road was what was described as a blind turn.
Yep.
So it was hard to, or essentially neither vehicle could tell what was coming in the opposite direction.
Don, do we know what the speeds of the relative vehicles was?
Well, again, I mean, this is a classic story, Tony, where both different versions of events. And it's a classic where you've got these country roads, blind bends, two vehicles, one oncoming, the other one, and they go around and there's a head-on collision and there's no witnesses. So really you're going through the versions of each driver, or in this case, the motorcyclist and the driver of the vehicle. Look, the driver says he was going between, between 30 and 40. The motorcyclist said 30 and 40 kilometres. And I believe, Alistair, is that right? I think the driver of the forward driver said similar as well. They both knew it was a blind corner.
It should be
around.
mentioned it was a 100-kilometre zone, so neither driver was speeding, but the question was, what's safe in the circumstances?
Correct. And the driver of the vehicle said he was on the left, entering the right-hand bend on his, left-hand bend coming from his way, and the motorcyclist said he was on his left. And then the version of the forward driver, he was saying that he saw the motorcyclist in the middle of the road. He applied his brakes and the course skidded across and hit him.
But can I ask you this? I can't work out, was there a sign on the bend to slow down?
Oh, I didn't go into that, I don't believe.
Because
Usually
I would have
there won't be,
thought-
Tony. There won't be country roads.
If this motorcyclist lost his case, I've preempted what's happened here. The motorcyclist did win. But what I want to know is this. If the motorcyclist had lost his case and the speed limit was 100 kilometres an hour on a gravel road, don't you think a claim would have been pretty strong against the local council or whoever was responsible for the road?
Oh, look, Tony, I mean, that's a whole different cause of action. And I think because we have so many country roads, there is a defence available to road authorities to say, well, look, it's just not within the budget to put sign on every single bend on a country road, which is used, although not as much as a major highway.
Yeah,
So there
but
is those considerations as well, and they have a lot of protection under the laws.
Yeah, but if this was in Victoria, they've still got the Road Management Act and they've still got to inspect, don't they?
That's right.
And if there's been no inspections, they're going to have some issues, I'd imagine.
Look, I think the question is if there'd been a lot of other similar accidents in the past so that the council was on notice, then maybe they might be in the gun. But if this is the first accident or one in a million type of accident, then it's not going to be an issue.
I don't think it's appropriate that on a gravel road that you've got a speed limit of 100 kilometres an hour, especially on a bend there's no signage.
Well, we don't know exactly what signage was there. It's not really mentioned. The issue is you're coming up to a blind bend. You don't know what's coming around the corner.
Yep.
A prudent driver might slow down.
So what did this cyclist win then?
Well, he won
Circumstances
because
where they
the
both
judge...
said the same thing.
Look, Tony, you got a case, and it's a classic case where there's he says, she said. In this case, he said, he said.
Yep.
And you have different versions of events. But so the judge was left to somewhat infer what he thought happened. Again, hindsight. And what he said was because if you look at these circumstances, the four-wheel drive, when he applied the brakes, caused him to slide. The motorcyclist said he was hugging the left hand, so he did everything he could to get out
Push
the way.
as far away as he could.
So the inference taken from that is because once a driver applied his brakes and it's caused him to slide, it maybe was going a bit too quick around the corner.
Okay. He didn't accept his evidence, obviously.
Exactly.
Okay. Well, it gets better than that for the motorcyclist because even though they said he was wearing dark clothes, his motorcycle was orange.
Essentially, the court held that the motorcyclist wasn't responsible at all for the accident.
I know, but I'm saying the fact that he had dark clothing but his motorcycle was bright orange would have helped his case because it would have meant that the driver on the other side had a better chance of seeing him.
Yeah, I think visibility is certainly a factor.
Anyway, interesting case. I would have thought that if he failed in his action, would have appealed and then maybe brought in the council or local authority that dealt with the road.
Yeah.
Maybe, possibly.
Yeah.
And look,
absolutely.
I think the motorcyclist sustained very significant injuries. I mean, the damages
$15,000.
appear to be agreed at $615,000. That's...
I like the approach where they agree on damages because it just short circuits the trial. I'm sick and tired of these 3 to 4 week trials where sadly the only one that's out of pocket is the punter, the poor injured person, gets a result, $615,000. You run a 4 week trial, they're lucky to get half of that. Because of the cost of running a trial.
Exactly.
There's so many shortfalls in these cases.
Yeah, absolutely.
Councils fees, engineers and doctors, etc.,
Expert
etc.
reports.
Yep. And that's something clients should take up with their lawyers. What is the cost of running a trial? O'Connor versus McGregor. Who wants to tell me the facts of this case?
Well, look, this is a pretty interesting case. It's a case brought by the dependents of a man by the name of O'Connor, who was killed in a transport accident. O'Connor was essentially walking home. He was a pedestrian heading home after a wedding. And he's walking along, again, another...
Dark road.
Dark road at night, a country road. I think there was little moonlight, so it was very dark. And a bus that, funnily enough, had been taking guests from the wedding home, had been hired that night to pick the guests up and take them home, ended up hitting the pedestrian, O'Connor, and causing a fatality. So the question in this case was, who's responsible for the accident? O'Connor had a blood alcohol level of 0.127%. So there was evidence from a toxicologist about the effect of alcohol and impairment. I think the toxicologist said that at anything over 0.3038%, you begin to be impaired. So that was taken into account.
So what did they find for the...
Well, look, you look at, obviously the pedestrian was walking with his back towards the traffic. The pedestrian was also wearing dark clothing, as Alistair mentioned. It was at night, I think 1:25 a.m. There wasn't even moonlight at that time, and they got to also look at what time the moon came and all that stuff. So they had a lot of evidence there, and he was intoxicated. The driver, who was driving what's described as a Nissan school bus, had 4 headlights on it, and they produced evidence from an expert to say what would have been his viewing distance. And the viewing distance would have been 60 metres to 100 metres in front. So ultimately what the court held was that the driver failed to see the pedestrian in circumstances where the pedestrian was there to be seen.
Okay.
The evidence, Tony, was that the bus driver didn't see the pedestrian at all.
But the evidence was that he should have seen him.
Exactly right.
Yeah.
Well, it was there to be seen.
Anyway,
And then ultimately, Tony, on the other side of that is that the court then had to consider any
His
contribution
contribution.
in negligence against a pedestrian, and found that the pedestrian was more at fault or more to blame than the
They took a
bus
fair
driver.
off.
Well, the bus driver only had a matter of seconds, whereas the pedestrian put himself from, because I think the party finished at 10 and this was at 1:25, again for those factors, alcohol, what he was wearing, and also walking with his back towards. So when we look at the split, Alistair, you want to tell them the split?
It was 1/3.
It was essentially 1/3.
I thought it was a bit harsh.
The bus driver was held to be 33% responsible for the accident for failing to see the pedestrian at all. The court held that had the bus driver been able to see the pedestrian, could have taken emergency evasive action and may have prevented the accident.
I thought 50-50 was a fair split. On that note, Alistair, thanks for coming on board. Don, always a pleasure. Viewers, thanks for watching. Stay tuned for future episodes. Go to our past episodes, go to our social media platform, and always remember to stay safe.